astuteness of making this the first place to hold this very crucial hearing and listening session. I want to acknowledge the Chairwoman of the House Administration Committee, Zoe Lofgren, Speaker Nancy Pelosi, for recognizing the crucialness of voting for there will be many hearings thereafter. And Congressman Vella, thank you so very much for being a host. I'm delighted to be here with my colleagues, Congressman Green and Chairwoman Johnson, Chairman Thompson, and the Assistant Speaker, as well as my colleague, Mr. Cuellar. I can say to you that the crucialness of this committee cannot be spoken enough of. And as a member of the Judiciary Committee, senior member, the work that we will do will be in collaboration with the important work of this great committee. I cannot speak without acknowledging the warriors that you have selected, the experts, Rolando Rios and George Corbel, as well as Mr. Bledsoe, who I don't know will be able to be here, Mr. Dunn, and certainly our representative from the ACLU, who is present. All of these gentlemen I have had the opportunity to work with, and Ms. Marzano, we thank you as well for the leadership that will be given to this hearing. Very briefly, we are at the epicenter of voting discrimination here in the state of Texas. And just 2 points, many more to be offered, but certainly those of us in the United States Congress are the beneficiaries of the Voting Rights Act, particularly Section 5 preclearance. We're in voting rights districts. Many of us are in voting rights district. The district that I am in now is a court-ordered district, done so out of a long-standing discrimination that we had to fight. From the very time I came to the United States Congress, I've never been totally in a district drawn by the state legislature. I only survived. This district only came about. Barbara Jordan was only elected because of the 1965 Voting Rights Act. So 2 points. Isn't it interesting that the Department of Justice has now indicated that the state of Texas should be withdrawn from any Section 5 preclearance? And number 2, that the Mexican American Legal Defense Fund has to file suit because the state of Texas, besides its discriminatory voter ID law, which has saw the closing of polling places, but now that they are holding up individuals whose driver's license may have indicated that they were not a citizen, but in fact they are a citizen. You get a driver's license in this state, no matter who you are, but you then process into citizenship. If we want to believe in one person, one vote, government of and by and for the people, then we must guard, protect, hold, and fight for voting rights, including Section 5. So thank you so very much. I close by acknowledging our chairman, very active gentleman, Mr. Hinojosa. We're very grateful for your leadership. And Ms. Belt, who is here, we're very grateful for her service. So thank you very much, Madam, and I yield back.
Thank you very much.
And again, let me emphasize the historic nature of this hearing. And to our host, Congressman Vella, again, as we hold this hearing in South Texas, it is really because of the experts that we have before us, really telling the history and story of the entire state of Texas. Let me again emphasize that the Honorable Barbara Jordan, who represented this district, would not have been elected had it not been for the 1965 Voting Rights Act. She went first to the state Senate on a district-line Senate, and then off to the United States Congress. But let me pose questions based upon my being on the Judiciary Committee when the panic went out that the Voting Rights Act was getting ready to end, and we had to create 15,000 pages that brought about the bill signed by President George W. Bush, obviously a Republican, and to try to track this questioning of state action and how vile that is, and maybe the word should go out that we're under attack again, and let the horrors of those who bombarded my office and the United States Congress phone saying, don't let the Voting Rights Act go out. I think the message needs to go out. We need them now. And so I want to pursue this line of questioning very quickly. Each of you will be a yes or no answer. Do you consider Texas one of the major epicenters of voter suppression? I'm going one by one. I just need...
Absolutely.
Yes.
Very much so.
Yes.
Do you believe that state action is clearly part of that voter suppression?
Absolutely, Councilman.
Yes.
Yes.
Absolutely. In fact, I'd say they were on the cutting edge of it here in the state.
Based on the holistic stories that you've been telling, let me go to this point. One, we know in the voter ID case, we had the Department of Justice documenting and supporting the position that Texas discriminated in redistricting. The voter ID law was discriminatory. You now know that we have a new announcement saying that the DOJ will flip and now support the state of Texas, where there's no intentional discrimination, which was found, and will indicate that we are no longer subject to pre-clearance Section 5, which obviously we've got to fix. It may take a little bit longer, but I'd appreciate...
within 2 hours...
Mr. Rios, yes.
Within 2 hours of the president swearing in, there was a notice filed in the federal court on the voter ID claiming that they were going to realign themselves within 2 hours.
What impact is that? When the people's lawyer, the federal law firm that was the instrument of change in the civil rights movement flips?
Has a tremendous impact, because now you have the federal government weighing in on important questions of law, and it has an impact on federal judges and the public at large too.
Mr. Dunn, is there any basis for that flip? Is there any fact basis that should generate a flip to go against us in terms of saying no discrimination in Texas sufficient for preclearance?
None whatsoever. And I would point out that the Department of Justice, the only federal department named after an idea, has fought for voting rights since it was given the charge in the 1965 Civil Rights Act and Voting Rights Act. And even during other Republican administrations, although they would take actions that I wouldn't necessarily agree with, we're consistent in enforcing voting rights, pursuing individual cases in communities. We've not seen any of that from the current administration.
I want to make the point that the bulk of the members on this panel, I would think my numbers are correct, are voting rights districts. And so two questions, you can take them, and what impact is demise and ending of the voting rights on the idea of one person, one vote, which is what we're supposed to be adhering to, number one. Number two, given the Shelby decision, what type of record do you think needs to be built that could pressure the Supreme Court in its present configuration that Section 5 preclearance is an absolute necessity to ensure one person, one vote, and to eliminate the intimidation that has come about through closing polling places, short hours, and, of course, purging?
Well,
document the record. It's very important, which is what you're doing.
The ability to influence and dilute others' votes is caustic to our democracy. And in the cut and thrust of politics, where sort of anything goes, as you know as well as you do in running for re-election and the various races you've had to face, it's hard for other candidates to not use a tool that's available to them. And the message that we are delivering lately is that diminishing the right to vote of people that don't support you as a candidate is a proper campaign method. And it's going to continue to increase until Congress, the Supreme Court, and government in general can do something about it. And so this is an important first step. It's my honor to be here.
Thank you.
Thank you. Thank you.
Mr. Green.